Good morning, ladies and gentlemen. Welcome to the ACITA national meeting. Because we can still not yet meet in person, we have split our March event into two sessions, one today and one again on the 23rd. And I do hope and pray that our next big event will allow us to meet in person. We are living in extremely exciting and uncertain times, and it does feel as if that face-to-face catch-up is just so way long overdue and absolutely necessary. The UK's vaccine rollout program appears to be working well, so an actual physical event in the not too distant future does seem like a realistic possibility. Let's all keep our fingers crossed. It's only been 76 days since we Brexited and left the European Union, and from an industry perspective, there remains frustration over the constant and ongoing lack of clarity. There are essentially no border controls for goods entering the UK from the European Union, and the phasing-in period of 6 months has just been extended by a further 6 months to 1 year. While this was welcomed by many industry sectors because they were simply not ready, there is tremendous frustration from various other industry sectors of the industry that have been prepared and ready time and time again for each of the numerous no-deal and implementation cliff edges that we've been threatened with over the last few years. There are businesses that that have actually spoken to me that specifically train staff in preparation for the changes on the 1st of April this year. And this sector is starting to feel consistently penalized for being prepared. I mean, my concern is that this attitude of constantly kicking the can down the road is only going to drive complacencies, and some sectors will never be ready. An additional obvious concern is how the EU going to react to the UK government's latest announcement of a further 6 months extension. Is there a realistic chance that they simply do not ratify the withdrawal agreement? And what are the implications of that not happening? We as ACITA will obviously monitor the situation closely and do our best to keep you, accordingly informed. But back to the business of the day. Kev, could we move on to the agenda slide, please? First up, we have Conservative Life PA in the House of Lords and former Cabinet Minister in both Margaret Thatcher and John Major's governments, providing us with a view of the UK's current and future trade outlook. Then HMRC addressing us on recent changes and their potential implications. This is followed up by Barrister Jeremy White giving us a bit of a view on the complexity and possible implications of some of the legal changes that have resulted from Brexit. We'll then have a short coffee break, which we found previously works quite well, after which HMRC will be taking us through a pretty comprehensive overview of how that has been impacted and what facilitations HMRC have in place to make our lives easier. As usual, please place any questions you have in the chat facility. I'll put these questions to our speakers at the end of their individual sessions if timing permits. Alternatively, we'll put these questions to our speakers in the Q&A session planned for the end of today's proceedings. Any questions that aren't answered in these sessions will be put to our speakers afterwards, and responses will be chased down by Kevin and published on the web, on the ACITA website. I think that is more than enough from me. So please let me introduce our first speaker. Lord Peter Lilly is a Conservative Life peer who has sat under this title in the House of Lords since 2018. He's been a Member of Parliament since 1983 and was previously the Secretary of State for Trade and Industry. Lord Lilly, your attendance and participation is very much appreciated. And the floor, if that is the correct virtual expression, is now yours. Ladies and gentlemen, Lord Peter Lilly.
Should I start again? I think you're mute, Des.
Yeah, I'm saying that sounds great. Thank you, Lord Libby. Please go ahead. Yeah.
So I'll start again. Right. Sorry. It's a great privilege to be asked to take part in this event this morning. Normally, I attend ACITA conferences to learn from you all about the complexities of customs procedures and the problems with which traders have to cope and the frustrations which you face, and Des has just outlined. So I feel a bit of a fraud being this side of the microphone. Now I've got it working. However, one of the few advantages of advancing years, and I'm nearly old enough to run for President of the United States, is that I can put things in historical and political perspective. It so happened that when I was Secretary of State for Trade and Industry in the 1990s, I was responsible for both implementing the European Single Market Programme and for negotiating the Uruguay trade round, which halved tariffs between developed countries worldwide and created the World Trade Organization. I made very bullish speeches at the time about how both the European Single Market and the World Trade Organization would boost Britain's exports. Looking back, however, the impact, particularly of the single market, was much less significant than we all expected at the start. Click chart. Yep. Indeed, over the last 2 decades, our goods exports to the 14 countries who initially comprised the single market have grown by barely 10%, less than 0.5% a year. By contrast, our exports to the 14 largest countries with whom we trade just on WTO terms without any free trade agreement have risen by 88% and now account for well over 1/3 of our goods exports. That growth partly reflects the rapid growth of those economies, whereas Europe has been the slowest growing continent in the world, apart possibly from Antarctica. The lesson I've drawn is that trade deals have far less impact on the level of our exports than most people assume. What drives exports is not trade agreements. It's producing goods and services people want to buy, getting out and selling them, preferably aided by a competitive exchange rate. Germany, for example, has no free trade agreement with China, but China is one of its largest trading partners because Germany produces the engineering goods which China needs at this stage of development. That doesn't mean that trade deals are unimportant. Their presence or absence can be critical for particular sectors. They can stimulate domestic competition, which is valuable, and they can reduce costs to consumers. But they're not what primarily determines the overall level of a country's exports. We're going to see fairly soon whether that turns out to be correct while we leave the single market. I currently sit on the Select Committee in the House of Lords on trade in goods with the European Union. We've been taking evidence from the immediate impact of Brexit on goods trade. And it's become clear that the worst things which we expected haven't happened, and the worst things that have happened, we didn't expect. So unlike the government's reasonable worst case scenario, we haven't seen 7,000 lorries queuing back up the M20 to get into Dover. The proportion of vehicles without proper documentation arriving at Dover has only been a tiny fraction of the 40 to 60% envisaged in the government's worst case scenario. And there have been no serious shortages of food, medicines, medical isotopes, etc. But the situation has been worse than expected in other areas. In particular, the problems experienced in trade with Northern Ireland, the problems faced by exporters of fish and the actual ban on export of bivalves, the VAT problems and differing VAT systems in member states. One issue which almost no one, to my knowledge, flagged up is the problem of re-exporting European Union goods from Great Britain to Ireland or to other parts of the EU, which makes redistribution from the GB almost impossible. And although the trade and cooperation agreement with the EU helpfully allows self-declaration of re-export of rules of origin, compliance with rules of origin seems to have been more significant as a problem than from the word go than most people foresaw. Some of these issues are, of course, learning problems and will diminish as long as traders persevere and become more familiar with the procedures. But others are structural. A number of witnesses to our committee were optimistic that negotiation in the network of committees established under the Trade and Cooperation Agreement would resolve these structural issues, at least where they affected trade in both directions. I personally wouldn't put much money on this. Of course, the reciprocal removal of barriers would benefit both the European Union and the UK. But the overriding priority of the European Union is not economic, it's political. It's to make sure that Brexit is seen to be a failure or at least a costly process, so as to discourage other member states from following our example. Unfortunately, Britain's conspicuous success in its vaccination programme has made the European Commission even more determined that we should be seen to suffer in other ways, even if that's at a cost to the European economy. So sadly, we'll see some traders, particularly some small traders and those involved in redistribution, withdrawing from the European market. Some economists have pointed out that most of those likely to be squeezed out of the market do not make a major contribution to value added in the United Kingdom. They're often distributing goods manufactured abroad or which have little UK content. That may be correct, but to the individual businesses concerned, the loss can be a sizable proportion of their livelihoods, or indeed can put the whole business at risk. So it's right that they should be given financial support to adapt to the new circumstances. And the government has been doing that. Can we have the next slide, please? The government's announced a fund to help small and medium-sized enterprises, which opened for applications the day before yesterday. It's also announced specific help for the fishing industry. In addition to the £100 million plan to help build up the capacity of our fleet, it's opened a special fund to compensate fishermen who've lost out due to the initial disruption of trade, and at the same time established a joint task force which is proactively seeking to minimize these problems. Where possible, both small and medium-sized enterprise and our fishing industry should be helped to find new markets at home or in the rest of the world. We should encourage British consumers to buy British food, British fish, British cars, etc., etc. There's actually plenty of scope for this. We're rather unusual. We export 80% of the fish we catch and import nearly 3/4 of the fish we consume. And figures for cars are very similar. We export, I think, something like 3/4 of the cars we produce and import more than 3/4 of the cars we buy, whereas Japan exports only 50% of the cars they produce and imports only 6% of the cars they consume. So there's room for a shift in consumer patterns. But the big problem's been in Northern Ireland. Can we turn to a blank screen? Despite the heroic efforts of Shankar Singham and the Trader Support Service, the problems resulting from the Northern Ireland Protocol are proving a nightmare. The TSS was established primarily to deal with custom procedures, rules of origin, tariffs, etc. But the greatest problems so far result from the sanitary and phytosanitary rules. Already the chief vet in Northern Ireland calculates that 20% of all the SPS checks on food and animal products throughout the European Union are now performed on trade between Great Britain and Northern Ireland. And that's while we're still in the grace period. When that ends, the number of checks will exceed all those carried out anywhere else in the European Union on international trade. That would require 200 extra vets who simply don't exist, working full-time. Now, how can this disparity exist? Are the checks disproportionately high relative to trade in Northern Ireland compared with those in other EU trade? There's a bit of that. The absurd rule that earth on second-hand tractors and must be steam cleaned to remove any scrap of GB soil, even though this steam cleaning process fuses the electronics of the tractors, was simply an overzealous application of EU law by British officials and has been stopped. But the basic reason why so many checks are carried out in Northern Ireland and so few elsewhere is that there's very little trade in these food and animal products into the EU elsewhere. And that's because the EU SPS rules largely prevent such trade. To be blunt, that's what they're intended to do, to protect EU food producers, not to ensure that EU consumers have access to safe food from abroad. And as those rules are progressively applied to trade between Northern Ireland and Great Britain, they will largely prevent trade in those products there too. Remember, these problems are occurring before any divergence has occurred between British and European rules and standards affecting food and food products, and before a whole range of EU law comes into force at the end of the now extended grace period. For example, then medicines will fall under EU rules. Imagine the implications if the EU government is no longer in charge of the supply of medicines available to its own citizens. So what's likely to happen to the Northern Ireland Protocol? There are three options. New slide, please. First, the EU could agree to major relaxation of their rules. For example, the simplest thing would be just as they agreed that EU tariffs need only be levied on goods from GP entering Northern Ireland, which are at risk of going on into the Republic. They could agree that single market rules, checks and compliance processes need only apply to goods arriving from GB, which are at risk of crossing the border into the Republic. The second option is that the UK could invoke Article 16 of the protocol, which allows either party to take necessary action to prevent trade divergence, social unrest, etc. Coupled with Clause 30 of the Withdrawal Act, which reserved the UK's sovereign right to overrule the withdrawal agreement. And third, the protocol could be replaced by an invisible border enforced largely digitally by mutual enforcement or by alternative arrangements, as was originally envisaged when these arrangements were being negotiated as the final outcome. I don't know which of those three things will happen, but what's clear to me is that the protocol is legally, practically, and logically unsustainable in its present form. As the new Lord Hannan has spelled out in the House of Lords, the protocol is unsustainable because it's based on an absurd and unequal proposition, namely that checks on goods between Northern Ireland and the Republic would threaten the Good Friday Agreement and possibly even threaten the peace, whereas checks on the far larger volume of trade between Northern Ireland and Great Britain would have no such consequences. We've already seen that the EU's initiated legal action against the UK for unilaterally extending the grace period. That could take years to come to court, if not resolved amicably beforehand, which is what the British government's hoping to achieve. Of more immediate concern is the EU Parliament's delay in ratifying the Trade and Cooperation Agreement until present, the date is the 30th of April. Theoretically, that's to allow the agreement to be translated into all the EU languages and tidied up. But leading figures in the European Parliament have threatened to oppose ratification if they're not satisfied with the UK's compliance with the Withdrawal Act, which is separate, of course, from the Trade and Compliance Act agreement. Now, a vote against ratification would mean we're left with no deal, the famous no deal outcome. I think that's unlikely, since the European Union would not like to take the blame for such an outcome. But it's not inconceivable that the Parliament will postpone ratification further in a game of chicken, tempting the United Kingdom to walk away and leave us with no deal. I trust the British government will not rise to that bait. But at the same time, there are plenty of people in the UK who are calling for the British government to retaliate in kind against the bureaucratic barriers to trade with the continent, not just in Northern Ireland, but at Calais and the Channel ports. In my view, that would be a dangerous path to go down. It would only be worthwhile where we could be confident that the outcome would be that both sides remove obstacles. But if we end up mirroring European Union protectionism, we will ultimately harm our own economy. Britain's always rejected protectionism, unlike the continent, because as Henry George said, protection is to do, next slide please, protection is to do to ourselves in time of peace what economies seek to do to us in time of war. Protection is effectively blockading yourself against the supply of foreign goods. Protectionism and bureaucracy may benefit particular sectors, but they damage the economy overall. It's no coincidence that a protectionist Europe has been the slowest growing continent on the planet. Now, how about trade with the rest of the world? As I said earlier, I think the importance of trade deals is exaggerated, and that's partly because the Uruguay round halved the average tariffs between developed countries to low single-digit figures, at least on non-agricultural products. Consequently, the most worthwhile trade deals now are with developing countries, which still maintain a high level of protection, with countries which have large markets and are growing very rapidly, and deals which focus on the service industries, which are Britain's greatest source of strength. The Liz Truss has already carried out 60 or more former rollover deals with countries which we had deals with under the EU. Some, like that with Japan, go a little further than the original EU deal, particularly on digital and data, and include provisions for expanding and deepening the terms of those deals in future. But the most interesting prospect is undoubtedly to join the Comprehensive and Progressive Trans-Pacific Partnership, the CPTPP. We've been invited to join that by Japan. 5 of the 11 members are fellow Commonwealth countries. Its total GDP is greater than that of the EU once we've joined, and is rising far faster. And Britain would have the extraordinary advantage of being the only non-Pacific member state. If nothing else, it would have a powerful psychological impact on the markets to which our exporters direct their attention. As for the possible deal with the United States, there are mixed signs from the Biden administration about their enthusiasm for carrying forward the negotiations which began under Trump for a UK-US trade deal. America did recently lift trade sanctions on the UK resulting from the Boeing-Airbus dispute, and did so ahead of lifting them against the EU. That was a positive signal, and particularly welcome to the Scottish malt whisky industry and the Kashmir producers. Unfortunately, the one thing the American Democratic Party share with Donald Trump is a lack of enthusiasm for free trade. So it's unlikely that we'll see a very rapid conclusion of any trade deal with the United States. India is the quintessential large, fast-growing, but still protectionist market. And Liz Truss has been energetically courting them. But again, an early agreement is not likely. Most of the old Commonwealth countries are members of the CPTPP and tend to be less protectionist. So in terms of reducing tariffs on our exports, there's less to be gained from trade deals with them. But they could be important partners in widening and deepening the scope of trade deals not least in the area of service trade and service industries. And undoubtedly, trade liberalization is best if it happens multilaterally through the World Trade Organization, rather than through a confusing cobweb of bilateral deals. As a substantial member of WTO, able for the first time in decades to put our weight behind a liberalization agenda, we could have a powerful influence. In particular, we can give new impetus to initiatives on a sectoral basis, plurilaterally, setting up groups of countries who agree to liberalize specific areas like data, which other countries would be free to join subsequently. And we'd undoubtedly be joined in that sort of initiative by our Commonwealth partners. To end up with a bit of good news, during the passage through Parliament of the Trade Bill and the Agricultural Bill, there was considerable resistance to the idea of us doing trade deals with the rest of the world. But to do those trade deals, we'll have to get the approval of Parliament. To get those bills through Parliament, the government had to set up a Trade and Agricultural Commission, which it was expected to be rather protectionist. It included spokesman for the National Farmers Union, not just one, but spokesman for each of the 4 component parts of the United Kingdom, as well as other people of a protectionist bent. So it was expected to come up with all sorts of obstacles to free trade agreements in future. But it hasn't done so. It's come up with a remarkably good report, which is in favor of reaching free trade deals, leading to 0 tariffs and 0 quotas, including on agriculture. Subject to trade partners agreeing standards, and with a mechanism in place where if the partner in the free trade agreement introduces anti-competitive market distortions, be they SCBS agreements or whatever, those can be countered by calculating the tariff equivalent to those measures and yourself introducing tariffs to protect your market in a proportionate and focused way. So Parliament looks as if it may be more open to trade deals than has been the case in the debate so far. But as I said, at the end of the day, our success as a trading nation won't come from negotiating trade deals, desirable though they are a second order factor. It's only by producing goods and services that people want, getting out and selling them, preferably with a competitive exchange rate, that we will prosper as a nation. Thank you.
Thank you very much, Lord Lilly. That was a wonderful presentation. And Des, would you like to take over?
Yeah, sorry, just struggling a bit there to unmute myself. Hi, Lord Lilly, thank you very, very much for that. I mean, very insightful. I've got a couple of questions, if you don't mind. First one is, UK export trade figures are down 40% on exports to the European Union. Is it too early to say that Brexit has been a disaster for UK export trade?
Yes, it is. And that's the view of the Office of National Statistics, which points out first that, if you remember, there was a total embargo on lorries going into France just for Christmas. Then that was relaxed, but they still had to have tests for COVID, and that had a major impact on trade. More important, there have been major stockpiling, and one can see that by the trade inflows in the months ahead of Brexit, and that was unwinding. And finally, in the course of the month and into February, we've seen trade return to nearer normal levels. Now, I'm not saying that Brexit won't have any effect in these early months. It clearly has and will on specific sectors, as I said, but I think it's unlikely to have anything like the sort of impact that we saw in the first weeks.
And thank you, Lord Lilly, and if I may, will you be remaining for the whole period of the presentation? We do have a Q&A section at the end, and I've got sort of quite a few questions for you. Would you be available at the?
Yes, I'll be happy to do that.
If I could just answer, ask one question before we move on, which I find quite interesting, but something you didn't sort of touch on. It says, can you comment on free ports? Will trying to become the Singapore of Europe not further alienate our closest neighbours, the European Union?
I'm not terribly worried about upsetting our neighbours if it made us as rich as Singapore. I think about when Singapore became independent, and remember, it was actually expelled from the Malaysian Federation, and Lee Kuan Yew burst into tears when he had to announce that to his cabinet. He thought it was a disaster for Singapore, the Singapore exit, as it were. They then had a standard of living that was 1/6 of the level of the United Kingdom. They now have a standard of living that's substantially higher than that of the United Kingdom. And it's not by, as is constantly referenced on the continent, by sort of undercutting and slave labor and low standards. It's by being very, very competitive, very high standards of education and training, of skills, high standards of production, and high standards of competitiveness, opening themselves to the world, so they have to be competitive with the best of the world. So we will only make ourselves successful if we have high standards, not low standards. The point about free ports is that they allow businesses to set up with less obstacles to setting up, less obstacles to importing and re-exporting goods, because the goods can come in tariff-free as long as they don't leave the free port area into the rest of the UK and be processed and be sent abroad. And that, in that respect, it's a bit similar to Singapore, which essentially began its successful career by being an entrepot port, and then from simply transshipping things to taking things onshore and manufacturing them into more advanced products and re-exporting them. So free trade areas, free ports will, I think, help revive the areas of the country where they operate, but they won't do it by undercutting Europe, but by being more dynamic, I hope, than Europe. The same is true of regulation. Again, our continental friends, I've been reading the debates in the French Senate. They set up a whole committee on how to sort of counteract Brexit. They're very afraid that it will make us more competitive, but they think it will make us more competitive by lowering standards and lowering wages and all that sort of thing. It won't. You don't make yourself richer by making yourself poorer. You don't make yourself have higher incomes by cutting your pay. What you do is by ensuring that you have rules, whether it be in free ports or across the whole country, which make it less burdensome to comply with those standards. So they're high standards, but easy to comply with, that it's easier to enter the sector so that they don't exclude new entrants who are often the bringers of higher standards and new ideas and new ways of making things, and which therefore encourage greater competition. So we should be looking for changes in our rules that don't reduce standards, but make easier access to industries, less burden of unnecessary form filling and so on to meet standards. And we can do that to the greatest extent within those free port areas, but do it across the country as well.
Thank you very, very much, Lord Lee. There are, as I say, there are quite a few questions that I'd like to put to you at the end, and the questions keep on coming in. Excellent. So obviously you piqued a bit of interest there. Thank you, do appreciate it. Our next speaker is David Falladi. David has become a great friend of ACITA's, keeping us updated and abreast of developments at HMRC. David was the driving force behind getting many of many answers you guys needed on grant queries. So a big thank you again to you, David, for that. David is going to provide us with a short HMRC perspective on recent changes and the potential implications thereof. I do hope David is available.
Yep. Can you hear me?
Yeah, absolutely. David,
fantastic. Always worth double checking that the IT is working before we get rolling. And as Des says, always happy to work with the ACITA and make sure your members have what you need to prepare for the various changes. So as Des has already mentioned, there were some changes last week. So it was kind of felt that today is a really good opportunity to talk through some of these with you, exactly what they are, some of the implications and the rationales behind them. I'm probably not going to take my full 20 minutes, but that is intentional, so we have a bit of time to do some Q&A now while the subject's kind of fresh in our minds. So what I'll start off by doing is just covering off the key bits from the HMRC side of things on the customs side, and I will touch later a little bit on some of the wider cross-government changes that come in as well, though I won't be able to comment or take too many questions on those as it's a bit outside of my expertise when it comes to customs, and equally I know we have VAT colleagues later, so again, just to I guess make sure we keep on scope of each of the sections. I'll be mainly covering the customs side of things. So as you will have heard, most traders will now have longer to prepare for full customs requirements, with checks and controls being introduced from the 1st of January 2022. So that's that 6-month extension. I'm trying to view this much more as an extension rather than a delay, which will kind of become apparent why I think it's important to think of it like that. So for goods imported before January 2022, most traders importing most goods from the EU to GB will be able to continue to delay that submitting information and payment of any customs duties to HMRC for up to 170 days after the point of import. And if using delayed declarations, the trader must make a simplified declaration into their own commercial records at the time of the import, and then they will be required to submit that supplementary declaration up to 175 days or 6 months later, and either be authorised for simplified customs declaration processes or appoint an authorised agent. So that's why that's the key bit in my mind of why we need to think of this as an extension rather than a delay, because that 6-month supplementary declaration is still in place. So if you've brought goods into the UK since the 1st of January, you'll still only have 6 months from that point. So say you brought something on the 1st of January, you'd have till the 1st of July to make that supplementary declarations. So there is still things that will need to be prepared for within the year rather than kind of looking fully to 2022. So I'd encourage others to think of it more as an extension than a delay. Of course, traders can choose to submit full customs declarations should they wish to do so. The requirements for safety and security declarations on imports, so that's the entry summary declarations, ENS, as there are plenty of initialisms that always fly around the customs world. And these will also be waived until the 1st of January 2022, and that was from the initial date of July 2021. For traders importing controlled goods, so those things like alcohol and tobacco products, as well as other goods that are deemed controlled, and there is a list available on gov.uk. Unfortunately, I can't recite it all off the top of my head. It's fairly comprehensive of what's included, though it's by far not most goods. It is still pretty limited. So for those controlled goods, you will need to continue to submit customs declarations to HMRC, and at locations without existing customs control systems, these must be pre-lodged into HMRC systems, and then traders then have up to 11:59 p.m. on the day after the goods have arrived to notify HMRC that those goods have indeed entered the country. And as I say, a full list of those goods is published on gov.uk. And full import controls will continue to apply on trade between the UK and third countries outside of the EU. So why have some of these changes been made? So throughout the pandemic, we've consistently reviewed how we can support businesses. And as we come out of the current lockdown, we're doing everything we can to help businesses get back on their feet as soon as possible, and avoiding any unnecessary risks to our recovery. We want them to be able to focus on getting back on their feet, and so we're delaying the introduction of some of those controls to give them a bit more space and time to focus on their immediate needs. It's also since we set out that initial timetable to provide the full import controls in July, there have been two more lockdowns, and the impact on businesses has been quite severe, and many businesses have not had the time and the resources to make the necessary preparations for the implementation of those full import controls, and therefore they're less ready than they would have otherwise been had there not been those further lockdowns. So say the government has decided to introduce those customs controls in stages, and extend that to the end of 2021, which again will help support the flow of goods and minimise that chance of congestion that, as Lord Lilly mentioned earlier, was one of the big concerns, though thankfully hasn't actually manifested itself to the extent we were concerned it might do. So for all goods entering GB through border locations without the existing systems for customs control, at the end of the transition, declarations must be made before the goods arrive. So that, again, that's for controlled goods or for from third countries. So for EU controlled goods, where a declaration into HMRC systems is required for imports, this must be pre-lodged into HMRC systems, and traders have up until 11:59 on the day after the day in which those goods have arrived to notify us. So that's I know I've said that already, but I really wanted to cover that again, because that is for those controlled goods, it is that differentiation between what is needed now and what will be needed going forward for the rest of this year. So the same process applies to EU non-controlled goods if traders have chosen not to make declarations in their own records. That's the EIDR thing that I'm sure I've talked to ACITA members about before, that delayed declaration system. And during this period, border locations without existing control systems, including roll-on, roll-off listed locations, will not be required to control EU goods on the basis of declarations. I know Des mentioned at the beginning about a feeling of potential disadvantage for those that have already taken steps to be prepared, but there are processes that will and have been required since January. So companies who are ready now will still need to deal with customs in the future, and they're now ready to trade with other countries as well, if they've taken those relevant steps. So they haven't wasted their money, and of course businesses can choose to submit declarations now if they're ready to do so, and then they're able to avoid needing to engage in that longer term process of supplementary declarations. And we are hearing a number of from quite a number of businesses that they are preferring to engage with doing full declarations rather than the delayed declaration process, because it's kind of once and done and get it sorted earlier rather than later. So for those that have spent money and time in preparing, it's not a case of that being wasted time and effort. If anything, it's being ahead of the curve and taking the right steps to be prepared. So I'll now go through some of the other dates that maybe are a bit more wider regarding the staging in of the different controls. And so some of these aren't related to HMRC, but for the interest of providing as wide an overview as I can for the changes that were announced last week, I felt it was probably worth at least giving a nod to a few of these, as I'm sure it'll be of interest to a number of members here today. So first of all, the requirements for export health certificates and pre-notification requirements for products of animal origin, POAO, and high-risk food not of animal origin will not be required until October 2021. So this is one of those ones that's due to be brought in April, and again, 6 months to October. And again, this is, as I was saying earlier, how I've been viewing this is, rather than a delay, it's an extension, because then, as I say, we've got the need for supplementary declarations to start being made as of the summer, as of July. Then you have some of these being brought in October, and then the full controls in January 2022, which are going to get take some use to getting to say that. So that's one of the ones for April. So as I've already said, customs import declarations will still be required, but the option to use deferred declaration scheme, including that supplementary declaration up to 175 days, which is near on 6 months after goods have been imported, has been extended to the 1st of January 2022. Safety and security declarations on imports will not be required until the 1st of January 2022. Physical SPS checks, so that's the sanitary and phytosanitary checks on those products of animal origin or high-risk food not of animal origin, and high-risk plants and plant products will not be required until the 1st of January 2022, and will take place at border control posts. So that's the physical checks on what I mentioned earlier about the export health certificates. Pre-notification requirements and documentary checks will be required on low-risk plants and plant products from January 2022. From March 2022, checks at border control posts will take place on live animals and low-risk plants and plant products. So again, this is much more of an extension, I think, of viewing it than a wholesale delay. And finally, border locations without existing customs control systems at the end of transition will not be required to control goods on the basis of declarations until the 1st of January 2022, until the declarations for all goods imported at such locations will need to be made before goods arrive, and where declarations are made into HMRC systems, again, HMRC traders, have up to that end of the following working day, which the goods have arrived, to notify us of the arrival of those goods. So just to recap a little bit finally before opening for questions for a few minutes, traders importing controlled goods from the EU are not eligible to use that delayed declarations that has been delayed. And at locations with existing systems, traders will have 3 hours from when the goods arrive to submit their declaration before the goods go into temporary storage. And that's where they can be stored for up to 90 days before being declared to customs. And at locations without existing systems, again, if they're pre-lodged, you have until the end of the following working day. Of course, as I've mentioned before, but it's just to make sure we're all, just to get those key messages across, traders still have that option to make full customs declarations or use staged controls if they're importing those non-controlled goods. And again, if you are using delayed, it's keeping a record in your own commercial records at the time of import, and then that supplementary declaration after 6 months. And again, that is a rolling 6 months. So things you may need to make a supplementary declaration in July, depending on when, or 6 months from the point you've brought those goods in. It's worth saying as well, customs duties and tariffs will still need to be paid. Delayed declarations just defer the point at which businesses will need to submit a declaration to HMRC and make payments. Full import controls will then be in effect from January 2022. So that's a bit of a quick whistle-stop tour of those changes. And I repeated myself a few times in that, but I kind of wanted to make sure that was kind of understood as best as possible of what those changes were, because I know they came in fairly late in the day last week, and I think we're actually kept very well under wraps than some such notifications and updates have been in the past. But happy to take some questions now for a few minutes, and I will try and hang around till the end for the wider Q&A, but happy to take any questions, Des, now that might have popped into the chat.
No, thank you very much, David. I mean, yeah, there are quite a few questions for you.
Always are.
Do you have a sense of how many traders are using deferred declarations versus full declarations currently?
We do not. It's something that we have been looking at. How do we get a real sense of that? Part of the problem and an issue being with this is with the safety and security waiver for what was 6 months now, a year, and with the nature of being able to be entered into their own records, we won't really get much of a sense of that until those supplementary declarations begin to start rolling in.
I think it sort of rolls into the next question, and that is something that is a huge concern to everyone. It says, how are HMR ensuring that traders are actually submitting declarations? I'm worried my competitors aren't doing the right thing, putting me at a commercial disadvantage. And this is a real concern. We're going through the 6 month period. We're going through that has now been extended to a year. I mean, you could have unscrupulous operators that are just going to take advantage during this 1 year period, sort of make a killing while it's good and close their business down on the 29th of December this year. Is HMRC doing something to prevent that? Mm-hmm.
Well, I know, Des, I think it's one that we've talked about in the past in other forums as well, of around compliance. Compliance isn't my area of expertise, but it's kind of reassuring. We're continuing to take our standard approach around risk-based and intelligence led compliance approach, and for those that we know have a history of non-compliance, they're unable to use that delayed declarations, but it's something we are aware of. We kind of are not able to kind of comment on live compliance issues, but it's not something we're oblivious to, if that kind of provides some reassurances. But what I would say is, and it's something I know I've mentioned in the past to other similar forums from other organisations, it's really important for all those in the supply chain to be talking with each other to ensure that the necessary steps are being taken, and who in the supply chain is taking those steps, because it can be fairly flexible at times around Incoterms and other such agreements and commercial agreements of who takes on responsibility for certain actions that need to be completed. So if anything, this is a plea to make sure that that traders, hauliers, intermediaries, customs agents, freight forwarders are really talking to each other to ensure I guess that they have peace of mind that the necessary steps have been taken, have taken place, so that you can have that kind of reassurance yourselves. Because I appreciate, it can be a concern of if someone else in the supply chain hasn't done their bit. So we can only kind of say, make sure that those conversations are happening throughout that supply chain to ensure the proper processes are being taken place, and then from the compliance side, we'll continue the standard approach HMRC takes of risk and intelligence based compliance.
Thank you. I'm going to save the rest for the last, except something that's popped in here sort of confidentially. It is saying, is a whistleblowing line not a good idea where people are currently aware of non-compliance happening? A thought for you. So, and,
I'll take away and pass on to, because as you can imagine, HMRC compliance is a fairly large sector of our business. And I do have contacts there that I speak to regularly on issues that, as you've already mentioned there, Des, it's conversations that are regularly happening about how do we best approach this, and what powers we have to ensure compliance across the board. But that's one that I will, if it doesn't already exist, I'll take away and I will make a suggestion of it.
Thank you, David. We've got a good few for you at the end of the session as well, but we've overrun. So I think you, thanks again. I think you all know our next speaker. Pump Court Chambers Barrister Jeremy White has helped ACITA members to try and understand the legal implications of changes to customs law and regulations over a number of years. With all the confusion, the implementation phases and operating under a yet unratified trade agreement, we thought Jeremy's insight would be more than useful. Jeremy, I hope you are there, and over to you, sir.
Thank you very much, Des, and thank you very much for inviting me. Good morning, everyone. I hope to make this rather light-hearted, which is my usual style. I'm afraid I can't see you smiling, so I hope that you will be amused as well as informed by this. I've just picked on a very short number of issues that you might like to have my view on. But the first slide, if you could, thank you, Kevin, is a slide indicating the UCC hokey cokey. So the UCC, and let's talk about the UCC in GB first of all. UCC in GB, it was brought in by legal effect by the European Communities Act 1972. Then it was taken out of legal effect by the European Union Withdrawal Act 2018, Section 1, simple repeal. But a little later on, a derogating provision having effect by the Interpretation Act, which will be relevant to a couple of later slides, Section 3 retains this concept of direct EU legislation, and that is legislation that was had direct effect before the IP completion day. It still has effect. So then it's in again. So it's in, out, in, and well, we don't shake it about yet. It's in, out, in, and then it goes out again, because the Taxation Cross-Border Trade Act of 2018 again provides a derogation, and this in Schedule 7, paragraph 1 says that direct EU customs legislation ceases to have effect with this expression: so far as imposing or otherwise applying in relation to any customs duty. That is a difficult one because it's not a textual amendment. What it means is that those parts of the GB, as we'll have to call it, GBUCC, they cease to have effect if they were in relation to imposing or otherwise applying in relation to any EU customs duty. But the rest is in force. So it's a case of what is in force is what has not been taken out. And therefore it's this process of subtraction. So you've got legislation by subtraction. Now, we would really dearly love someone who would do this work for us, but this is the law. This subtraction exercise is the law, and this is what we will have to do. We don't have any, there isn't anything that we can rely on other than our own exercise of judgment in order to determine this subtraction exercise. You'll appreciate what it means is that we now have two legal texts. We have in Northern Ireland and the EU, we have the UCC that is maintained by the EU in their process of legislation, and that is a version of UCC. But we have a GB version of the UCC that is law also in the UK, and it is a different version altogether, and it has the force of law. And the worst of it is that it doesn't have to be the same. And what the UK has done already is that it has amended the GB version of the UCC by way of textual amendment. So even if somebody says to you they're relying on an article of the UCC, you have to say, are you relying on the article of the GB UCC or the article of the EU UCC? This is not, you might say that this is not a good way of legislating fundamental provisions of customs law, and you might well be right, but I couldn't possibly comment on that. So that's the position we are on the UCC. I can answer questions on that if you wish, but this is just really as a warning about where you need to take care when you're talking about the provisions of the UCC. If I could have the next slide, please. So this slide, wrong makers grommets. This is quite serious, light-hearted, thanks to Nick Park and the Wallace and Gromit movies, particularly Wrong Trousers. I've given you the words of at least the headings, and then some of the words of Section 33 of the Taxation Cross-Border Trade Act 2018. This is serious because this relates to charging provisions, the fundamental provisions of law that mean that all of the goods imported into the United Kingdom are subject to duties or are exempt from duties. It is a fundamental charging provisions. And so we have, we read in Section 1, the heading there of it's the charge to import duty, but it's a charge only on chargeable goods. So then we ask, well, what are chargeable goods? And chargeable goods are all goods save domestic goods. So then we find out, well, what are domestic goods? And domestic goods are defined by Section 33. So these are the goods accepted from charge because they are not chargeable goods, because they are domestic goods. And so we find that goods cease to be domestic goods if they've been exported. And then in subsection 4, for the purposes of subsection 3, every export of goods is required to be made in accordance with the applicable export provisions, unless an exception provided for by the regulations is made in by HMRC commissioners applies to the export. So these are regulations to be made by the HMRC commissioners, which will relate to the definition of domestic goods, which is relevant to whether they are chargeable goods, which is relevant to whether they pay duty or not. Now, the commissioners are to make up this list of exceptions by way of regulations. So then you say, well, we've left for a while. What regulations do we have? Well, the only regulations we have are the Customs Export EU Exit Regulations 2019, number 108. And its preamble tells you who made it, who were the makers, and the makers are the Treasury, not HMRC commissioners. That is a serious problem. You might think then that the basic charging provisions for all imports are therefore defective in some way. And you might well be right. I was expecting this to be corrected, but this particular instrument has been amended already and still hasn't been corrected. So what that means is, since it relates to an exception, it's probably, and it would withdraw the benefit of an exception, it's probably an error that acts in favor of the tax collector rather than traders' undertakings. But still, it's still not right. It's still bad. Okay. Then the next slide, you might have to direct me on time, Des, as to I don't know your timetable of whether you want me to speed up. I've got 5 slides in all, so we've done 2 so far.
13 minutes to go, sir.
I beg your pardon, Des? 13
minutes to go.
13 minutes. Oh, that's excellent. We'll be fine. And I will allow, I hope if I can leave some time for some questions, that might be helpful, or I can answer questions at the end. So the next slide is references to reference documents. Now, everything has been done in a rush. We know everything was done by everyone acting in goodwill. The structure that has been used is, there are acts, there are statutory instruments, there are public notices, and there are also reference documents. The problem is that the public notices and the reference documents are not enactments governed by the Interpretation Act. So to be given force of law, they need special treatment. And if the special treatment's not there, then they don't have effect. And also in their structure, they are, particularly reference documents, they're new animals, and they therefore have to be interpreted under new rules, which will evolve as time goes on, but can cause us some problems straight away. I've given you here the extract from the Reliefs SI that brings in the Reliefs document, the UK Reliefs document. And you see there that the Reliefs document that's given force of law is version 1.0 dated the 8th of December 2020. There is a footnote in there, footnote 4, which says that it's available electronically. So it's all good. It's all good so far, but it tells you where you can find the law. The problem is, and this is past the quotation marks, if you look on that, electronic link, you'll find that there is a version 1.1, 17th of December, and there's a version 1.0 of the 8th of December 2020. So which version has the force of law? Well, if it were an enactment, you would say it would be the version that was in force at the time after it was made. So for now, version 1.1 would be in force. But since this isn't an enactment, we do not know which one is how we should interpret this. Some literal interpreters of legislation said, well, it's only the 1.0 version. That can be a problem, particularly when on some of the reference documents where they correct errors of intent and they put benefits to traders, or they provide very important information in respect to the tariff, etc. That conclusion is a bad conclusion, because it would mean HMRC will have to collect tax on an avowedly incorrect basis. Anyway, that's the situation that we're in. That's how the government has decided to put customs law. That's the basis on which they put customs law now. Reference documents that aren't, whose amendments and new versions are not kept up to date. Right. The next slide, please. Thank you, Kevin. Is on how, well, actually, if you've got a reference document, how do you interpret? Well, I've already told you you've got the problem that you don't have assistance of the Interpretation Act. But how otherwise do you interpret it? Well, I just chose the Reliefs one, the Reliefs document, because I mentioned it in the earlier slide, and I've reproduced their return goods relief because I know that's some excitement at the moment. And the provision of the relief, as cited initially in goods eligible for the relief in 37.1, says that it's goods that have previously been exported as United Kingdom domestic goods. Now that is then, we know that this is law, therefore this is a provision of law, and it's a description of goods of a certain kind. And then later on, though, it has this other paragraph which says eligibility criteria and relief conditions, and it has it then has three provisions. It has goods exported as domestic goods, and then it's got two different kinds of goods that have been transported in bullets 2 and 3. Now, what is the position here? Do we have two rules, or do we have particulars of an earlier rule? But it doesn't say how we're to interpret it. And you might say, well, I'm being just very fussy. Of course, it means that the first rule is derogated by the later rule, because that's how you read legislation. You don't automatically read legislation like that. It's only because of other provisions, and yet we do not have any law as to how do you interpret such reference documents, which we would need, or they need to be drafted better so that the first rule, if it is particularized, says something like subject to. Legal kinds of words are used. If they're going to bring in law that is not that doesn't look like law, then they've got a problem. It should, even if it's a reference document, even if it looks as if it's just like reading front page of the Times, you should still have legal type hooks and in it to make sense of it, which they've not yet done. So that's that one. Then the last one is where the people, because now we're all treating. So the next slide, please. This is where we could find. This is on the trade and cooperation agreements. If we could just move on to the next slide. I can introduce it. You don't necessarily need a slide, but thank you very much. You will have read that now. You don't have to read all of it, but I think that the words are important that we read at least 1 and 3 of the TCA article, Goods 8 Repaired Goods. And it's so simple that it looks as if it looks too good to be true if you just read 1 and 3. What we have here then, the goods which have been exported for repair are not subject to any import duty. So it sounds fantastic. Why bother then to go through all of the difficulty of being authorized for IPR or OPR if you've got this provision, which looks to be like a provision that affects scope of charge or exemption or relief. Now, I'm saying that it is too good to be true. This is where we've been teased, but I think the problem is we aren't able to meet together, and everything is happening so quickly, and we haven't had trade agreements described to us. But usually, the international convention is that such trade agreements, and this follows the pattern of other trade agreements, that such articles are, to use the term when we join the EU, they don't have direct effects and they're not directly applicable. So they are obligations of the parties of the UK and the EU. They are not. They don't convert. They don't themselves, or the TCA doesn't grant any rights to individuals and undertakings. But what the UK has done, it has enacted this European Union Future Relationship Act in section 29. So I've reproduced it for you, because what it says is that the UK domestic law has effect with modifications so far as are necessary for the purpose of complying with the UK's obligations. This is a dangerous sort of section to enact, because it means that, and this is the point, if you can find anywhere within the scope of a UK charge, exemption, relief, or conditions of IP or OP, you can find a provision and then say that it needs a necessary modification in order to comply with the Goods 8 article, and then you can apply it in practice. You must be granted that relief given by that modification. And the only thing you have, if you did feel lucky, you would just have to hope that HMRC or a judge would agree with you, because then the judge would have to determine whether the modification that you introduced was in fact the kind that was a necessary modification. Sorry, a bit fast there, but I hope that makes sense. This is an example of where, under I wanted to just bring this slide in to give you an example of where you need to be careful reading the various layers and levels of legislation that is applicable, but it might not give you a right, and that it relates. So you can be teased by the TCA in a number of places. You can be teased by any number of the other international agreements, like the Northern Ireland Protocol as well. So thanks for listening. I'll put Des back in control, and I'll answer any questions now or later, as you see fit.
Thank you. I think the first is an interesting one, Jeremy. Thank you very, very much. It says, when can we get our hands on Jeremy's Customs Duties Handbook 2021? This shows it's desperately needed.
You're right, and you should probably go speak to LexisNexis and say that they need to pay me a huge amount of money so that I stop doing this work for clients and I do what I say needs to be done. So what I would do is go through all the legislation, do this process of subtraction for people so that they would know which parts of the GB, which parts of the UCC are now GB and EU UCC, and that should happen. The thing is that isn't going to happen. There is no one who has enough time or enough money to do that sort of work, and how long it would take. It would be helpful if we had some assistance from HMRC or the Treasury. If they're able to do so, they might well be able to do something, but they're not keeping they've had so much to do, all with the best will in the world. So my relationship with LexisNexis is that they do intend to do something appropriate and do their best, but it'll be later in the year. They've tried to do that first, and so the guys who will be able to, who are working hard on this, they're very good. They're the ones who do the real work, not me. They will be able to work on it later in the years, but I'm afraid not before, probably not before autumn.
Okay, I've got a couple more questions here which look like people seeking free legal advice, if I'm perfectly honest. So what I think I will do is I'm going to save those until the end, Jeremy. I mean, it is now sort of 19 minutes past 11, which means that I think this is the first time I've ever known you to actually finish on time. So thank you very, very much. We have a 5-minute coffee break scheduled in here, which I see has worked sort of quite well in the past. So if we all take 5 minutes, go and grab ourselves a cup of coffee or cup of tea, and see you back here at 25 past. So thank you, Jeremy. We'll be back with you guys.
You're welcome.
Ladies and gentlemen, welcome back. Hope you all had time to get yourself a cup of coffee. I've got one, feels so much better. Been a really great session so far this morning. But to the business of the day, we struggled for a while to get someone from HMRC to talk to us about VAT. So I was really pleased when Dinesh and Kevin told me that Helen had agreed to tackle this topic for our membership today. And then I saw the comprehensive presentation which you are about to take us through, and I smiled even more. I mean, thank you so much. So without me wasting any more time, I hope that Helen and her team is available and we can kick off this afternoon session. Helen, are you there?
Hi, I am, yeah.
Over to you then, thank you.
Hi, Alan. Did you want me to come in with the first section? So I'm David Pruden. Hopefully you can hear me fine. I do occasionally have connectivity problems, and because I'm talking into a very small iPhone, you won't, unlike other presenters, be able to see me because you just see my mouth if I did so. So I'll cover the first section. So if we can just go to the next slide, please. So I will cover the material up to the accessing the PVA statement bullet there. So I think this is about the first sort of 9 slides I'll cover, and we'll then hand over. So thank you. If you can go to the next slide, please. So yeah, so if I just introduce myself a bit more. So I'm David Pruden. I work for HMRC in VAT policy. So I have been working mainly for the last 2.5 years on the introduction of postponed VAT accounting, which is a large part of what I will now be covering. So I'll go through that, and then happy to take any questions later on, of course. And the other thing I would say is that I will mainly be focusing, and I think probably that's true of all of us, probably talking mainly about VAT registered traders, but there will be certain instances where we're talking about non-VAT registered traders, and we'll make clear to you when we're doing so. So the first slide is that you have there is just one on exports and dispatches, and this is just as things changed or stood from the 1st of January 2021 from, as I said, the perspective of VAT registered business. So movements of goods from Great Britain to the EU are exports, but movements of goods from Northern Ireland to the EU continue to be dispatches. So that means for goods moving from Northern Ireland to the EU, the previous intercommunity rules will remain, and supplies between VAT registered businesses, so B2B supplies, are zero rated as dispatches. The next bullet is a specific excise requirement. I'll just read it. Northern Ireland to EU business to consumer, so that's VAT registered business to either non-VAT registered business or consumer. Supplies of excise goods require the seller to register for VAT in the place of consumption, and there's no threshold for doing that. And the movement of the goods is a deemed supply of the transfer of own goods. But the more general point is the last one there, which is for exports from GB to the EU, goods will be zero rated, and whether they are excise goods or not. So next slide, please. So this is the reverse situation, and I'll be concentrating on imports from now on. So from the 1st of January 2021, again, from the perspective of VAT registered business, movements of goods from the EU to GB are imports, so no longer acquisitions. So import VAT rather than acquisition VAT is due, but acquisition VAT continues to be due on goods moved from the EU to Northern Ireland. Postponed VAT accounting is available to UK VAT registered traders who import goods into GB from anywhere outside the UK, or import goods into Northern Ireland from both outside the UK and the EU. And what postponed VAT accounting does is allow importers to account for and recover import VAT on the same VAT return. Other existing means of paying import VAT remain available, So either paying up front or using a duty deferment account. And if you're not VAT registered, that's how you will pay your import VAT when you make your customs declaration. There are different rules on consignments valued at £135 or less, excluding excise. That will be covered in later slides. So next slide, please. So postponed VAT accounting is selected on the customs declaration. And if you're a chief user, which virtually everyone will be, it's the EORI of the trader that you need to enter. If you're using CDS, it will be the VAT registration number that you enter. So an online monthly postponed import VAT statement is generated, which the trader is able to access and download. I'll say a little bit more about that later on. And that contains the information the trader needs to complete their VAT return. You do not need to be authorised to use postponed VAT accounting, but you do need to subscribe to CDS to access your PVA statements. To use PVA, the imported goods must be for use in the trader's business. I'll say a little bit more about that later on. And non-established taxable persons, so they are entitled to use postponed VAT accounting, but the general requirement for non-established taxable persons applies, which is that in order to import goods into the UK, a non-established taxable person does need to hold a UK EORI and does need to instruct an agent to make the customs declaration on their behalf. So next slide, already there. So postponed VAT accounting can be used when, so just a couple of further categories. So postponed VAT accounting can be used when imported goods are removed into free circulation from a customs special procedure. It can be used for excise, so it can be used at the point that imported excise goods are released for home consumption. And that includes when the imported goods are released from an excise warehouse, having been in duty suspense since the time that they were imported. Now, the use of postponed VAT accounting is normally optional. However, traders who import non-controlled goods into GB from the EU between the 1st of January and the 31st of December this year have to use PVA and account for import VAT on their VAT return. And that's either if they delay their customs declaration or if they use the EIDR procedure and don't declare and don't delay them. So if you use the EIDR procedure, essentially you have to use postponed VAT accounting. A little bit more about that later on. But if you notice that the date to which this applies is any date between the 1st of January and the 31st of December this year. And that recently changed with the announcement last week of the extension of stage customs controls and the time to which delayed declarations may be used. Next slide, please. So yeah, if you use someone to import goods on your behalf, so if you, as most traders I think will, get a person or business to import goods on your behalf, and this is really anyone, it can be a freight forwarder, customs agent, broker, fast parcel operator, then you need to tell them how you want to account for the VAT on those imports so they can complete the customs declaration on your behalf in the way that you wish them to do so. So that is simply a general point. You have to clearly communicate to the person acting on your behalf whether or not you wish to use PVA. And if you're already importing goods from the rest of the world before the 31st of December, you're likely already to have an agent who will be doing this for you, but they obviously won't be using postponed VAT accounting, or won't have done because it didn't exist until the 1st of January. So you do need to arrange with them to change to using postponed VAT accounting if that is what you want to do. As ever, always important to keep a written record of what's agreed to avoid any confusion in the future. I would say we are getting some feedback that that some traders wishing to use PVA have not actually had a clear agreement with the person acting on their behalf, which means that they are putting sales through without using PVA when they did wish to use PVA, which obviously does entail the cash flow consequences if they do that. Now, in those cases, then put that right for the future. But it does make the point, clarity between yourself and the person acting for you is key here. A bit on business and non-business. So essentially you can use postponed VAT accounting. We've made it available where at all possible. So as I said before, it's where goods need to be, it's where goods are for use in the business. But essentially by that, we mean that you can use postponed VAT accounting to account for import VAT on your VAT return. If you import goods which are going to be used for both business and non-business purposes, or if you don't know at the time that you import them whether or not they will be used for business purposes or not. That means when you come to complete the VAT return, at that point, you will be accounting for the import VAT on your VAT return, and you can make the judgment then on whether you're entitled to deduct the import VAT as import tax. But in those circumstances, you will have been able to use PVA. The only time you can't use PVA is if you know when you import the goods that they will not be used for for non-business purposes. Sorry, they will not be used for business purposes, and then you do have to complete your customs declaration in that respect. We do have some guidance on that, and we are clarifying that guidance in some specific circumstances, hopefully in the next week. So I would look out for that if the issue around business and non-business affects you. The guidance I'll give you a link to later on will be supplemented hopefully in the next week or so. So when you complete the VAT return, so there are changes to the way the VAT return is completed. Essentially, it's box 1 which changes. You include any import VAT due under under postponed VAT accounting does need to go in box 1. That you then reclaim that in box 4, and you include the net value of imports in box 7. But you would have done that anyway. So the normal rules, touching on what I said in the last slide, the normal rules on when you can and can't reclaim import VAT apply. So yes, if you're a fully taxable person, then generally it's an in-out entry on your VAT return. The import VAT you declare in box 1 will, if you're fully taxable, be the same as the VAT import VAT you can then claim back as import tax in box 4. Yes, and as I said, the PVA statement gives you the information you need on that. If you delay the supplementary declaration, so this is the stage customs controls reference that I gave a few slides back, you won't have the PVA statement in front of you when you come to complete your VAT return because you've chosen to delay that. So in those instances, you need to estimate the import VAT due from the records that you have of imported goods. So from your commercial records, from how you completed your EIDR, there's a little bit of guidance about that and how best to make your estimate in the guidance link that I give at the end. Well, it's at the end of this slide pack, so there's a link there to the relevant guidance. And then when you do submit the delayed declaration, you then select you're using PVA. Your next online PVA statement will then show the amount of import VAT due on that declaration. And if necessary, you can then adjust the estimate on your following VAT return. So next slide, please. So traders do need to access CDS to view and download their monthly PVA statement. So if you're using Chief, as most are, the only reason that you're signing up for and using CDS at this stage is for the purposes of accessing your PVA statement. If you already have access to CDS, it's a slightly different process. I probably won't go to the full details of this. It's a slightly different process depending whether you've already had CDS, where you go straight to the start page, or if you need to sign up for CDS because you haven't used it, then you have to do that, and then you'll get access to the statements. So the monthly postponed PVA statements for January and February, which show the total import VAT postponed for those months, are available. There is a particular issue with VAT groups, which is different from the way that it used to work for C79s, which is that each member of the VAT group does have their own EORI and does individually need to sign up for CDS to access their statements. and then they will have to forward those statements to the representative member, who will then collate them to complete the VAT return. And we realise that's different and a more complex process than existed previously. I would also say that there have been significant problems with the procedure for making PVA statements available for both January and February, and we're working really hard to resolve those. But there have been difficulty both with people being able to access them, and then that the information on those statements isn't accurate. The number of different issues, we're trying to resolve all of those, and we will try and we will look to get guidance back out on how to complete the VAT return in those circumstances as soon as we're able to. So there's a box at the top of the second page of the PVA guidance which says that at the moment. But yes, look out for us being able to update that as soon as we're able. But if you do have any further issues, then you can obviously come back through to me, and we will assist to make sure you have the best information available if you're putting in a VAT return ending February. So that's me done, and I'll sort of hand over to the next section. Thank you.
Okay, thanks, David, and hello, everyone. I'm Will Pereira. I also work in VAT policy and in HMRC, and I'll be talking through the next couple of slides on consignments valued at £135 or less. So if we could have the next slide, please. Thank you. So the UK has introduced a new model for the VAT treatment of overseas goods, and this is to improve both the efficiency and compliance of businesses accounting for VAT. The new model applies to goods imported into Great Britain from overseas and goods imported into Northern Ireland from outside the EU. One of the main changes here is that VAT collection on consignments of goods valued at £135 or less has been shifted away from the border, and businesses liable for the VAT now have to register and account for it on their VAT return. So for goods located outside the UK at the point of sale and sold to customers in the UK, specifically in Great Britain, those customers will have UK VAT charged at the point of sale. For goods located outside the UK and EU at the point of sale and sold to customers in Northern Ireland, those customers will have import VAT charged. Another key change we have introduced places greater responsibility on online marketplaces in the collection of VAT. So where an online marketplace is involved in facilitating the sale, it will be responsible for charging, collecting, and accounting for the VAT instead of the seller. For goods sold by direct sellers, so without any marketplace involvement, the seller will be required to register and account for the VAT. And just to clarify the £135 limit, the limit applies to the total value of the entire consignment, not the separate value of individual items within a consignment. Another key change is that low value consignment relief, also known as LVCR, this was an import VAT relief for consignments valued at £15 or less. So this has been removed, so VAT will now be due on all goods supplied from overseas. Could we have the next slide, please? Thank you. So for business to consumer supplies, or B2C, this is where the customer is not registered for VAT in the UK, or where a VAT registered customer does not provide its VAT registration number, that will also be treated as B2C. So here, the seller or the online marketplace where it facilitates the supply will be liable to register and account for UK VAT on their VAT return. If they are already registered for VAT, they will not need to register again. And for business to business supplies, or B2B, this is where a UK VAT registered customer provides its VAT registration number to the seller or online marketplace. So here, the VAT registered business customer is responsible for accounting for any VAT due on their VAT return. For goods imported into Great Britain, this is done by a reverse charge. And for goods imported into Northern Ireland, this is done using postponed VAT accounting. Businesses will be able to recover the VAT as input tax, subject to the normal recovery rules. The final point to make here is that there are some exceptions to the rules I've covered over the last two slides. So the rules do not apply to consignments containing excise goods or to non-commercial transactions between private individuals, also known as C2C, and it would include things like gifts. So these goods will be subject to the rules for consignments of goods exceeding £135, with import VAT typically collected at the border. Okay, I think that's it for this section. Could we have the next slide, please? And I think I'm handing over to, I think it's Phil.
Thanks, Will. Yeah, good afternoon, good morning, everyone. My name's Phil Crawley and I work within the Northern Ireland VAT policy and delivery team at HMRC. I'll be talking through how VAT will operate under the Northern Ireland Protocol in this part of the presentation. So next slide, please. So talking about movements between Great Britain and Northern Ireland and vice versa first. For most transactions where goods are sold between Great Britain and Northern Ireland, VAT registered sellers should continue to charge their customers VAT and account for it on their VAT return. However, it will now be import VAT and subject to import VAT rules, including on valuation. This means that VAT will be calculated on the customs value of the good, which includes incidental expenses such as transport and insurance costs, as well as any customs or excise duties that are due on the import. Import VAT will not need to be paid at the point of arrival into Great Britain or Northern Ireland, as it will be accounted for via the VAT return instead in most cases. The customer, if VAT registered, will be able to reclaim input VAT subject to normal rules. This basically applies where the goods are used to make a taxable supply. However, there is a new requirement where a business moves its own goods from Great Britain to Northern Ireland. Import VAT will now be due. The business may reclaim that VAT as input tax subject to the normal rules. So there should be no tax effect for taxable businesses, as they will claim input VAT in box 4 in the same return as they account for the output tax in box 1. An import VAT charge will not arise where a business moves its own goods from Northern Ireland to Great Britain, unless this is done as part of a sale or supply of the goods. Next slide, please. There are some exceptions to the previous slide where seller liability will not apply. So where goods are subject to domestic reverse charge rules, the customer will continue to account for the VAT via the VAT return and can continue to reclaim input VAT subject to the normal rules. Additionally, goods declared into a special customs procedure, such as customs warehousing, where this is used, the customer or importer must account for the VAT when the goods exit the procedure. Goods subject to an onward supply procedure. Now, this would be available where the goods move from Great Britain to Northern Ireland and are consigned to be moved onto a final destination in an EU member state within 1 month. In this case, the final customer in the EU is required to account for the VAT as acquisition VAT. The importer can zero rate the goods, but they would need to include this onward supply on their EC sales list. And finally, goods sold by a non-UK seller through an online marketplace, as stated previously. In this case, the online marketplace is liable to account for the VAT. Next slide, please. Moving on to VAT groups. VAT groups can continue to include members established in Northern Ireland, as well as members established in Great Britain. So there is no requirement to restructure a VAT group, which includes members in both of those territories. Additionally, broadly speaking, transactions between UK VAT group members will continue as now, and in most cases can be disregarded for VAT purposes. However, there are a small number of exceptions. Supplies between group members where the goods move from Great Britain to Northern Ireland should be accounted for in the same way as a movement of own goods. So this is where the business should account for output VAT and input VAT entries on their VAT return. Also, supplies of goods in Northern Ireland between members where at least one member is not established in Northern Ireland. In this case, the VAT cannot be disregarded and will apply. The group's representative member should account for this and can reclaim the VAT subject to the normal rules. Next slide, please. Now looking at goods moved by non-VAT registered businesses or individuals. Goods moved or sent from Great Britain to Northern Ireland by unregistered businesses or individuals will incur import VAT, though in most cases the liability will be reduced to zero. This is because a credit will be applied which is valued at the amount of VAT that has been previously paid on the goods in Great Britain. As it is rare for the value to have increased between buying an item in Great Britain and sending it to Northern Ireland, the credit will cover any import VAT liability that would be due in most cases. However, in cases where goods have not already had VAT charged on purchase, or where the value of the goods has significantly increased since purchase, the credit will not cover the full liability and import VAT will be due. Next slide, please. Goods moved or sent from Northern Ireland to Great Britain by individuals and non-VAT registered businesses will not incur import VAT unless they have been subject to a VAT res claim. The VAT res scheme will continue to be available in Northern Ireland, allowing visitors from outside the EU to recover the VAT on purchases they make and then take home in their luggage. It will technically continue to be available for NI retailers to visitors from Great Britain, although the retailer must collect the GB import VAT due on behalf of the customer and account for it on their VAT return. The retailer can only refund the supply VAT to the customer once the VAT 407 form has been returned to them, having been stamped by a customs officer when the customer leaves Northern Ireland or the EU, for example, if they were to return home via Dublin. However, the VAT refund given and the import VAT charged by the seller should be the same amount and net off to zero. So for this reason, retailers may decide not to offer VAT res to visitors from Great Britain. Next slide, please. So as stated earlier in the presentation, in line with the Northern Ireland Protocol, suppliers of goods from Northern Ireland to the EU and vice versa will continue to follow intra-EU rules for VAT. So in terms of the VAT process, this is going to remain pretty much as it was prior to the end of the transition period. When talking about suppliers from NI to the EU and vice versa, we focus on where the goods started and where it ended, not where the business is established. So for example, a business established in London sending a good from its warehouse in Belfast to a customer in Dublin, they would need to account for this transaction as an intra-EU supply. The supply of services is not covered by the NI protocol. However, the rules for the place of supply of services are broadly unchanged. Some of the exceptions are covered below in the slide. Further information can be found in HMRC guidance covering these. Next slide, please. So for business to consumer sales, this is where the customer is not VAT registered. Distance selling rules continue to apply. For sales from an EU member state to Northern Ireland, where a business exceeds the Northern Ireland distance selling threshold, they must register and account for UK VAT on their NI distance sales. For sales from Northern Ireland to EU member states, now it's important to take account of each individual EU member state's own annual distance selling threshold. So for example, France would have a particular distance selling threshold per annum. And once a business sells more than that amount of goods to French customers, they would need to account for French VAT and they would need to register for VAT in France. So businesses should ensure that they're aware of each member state's threshold when they are making sales to consumers there. For business to business sales, where the customer is VAT registered, the customer should account for acquisition VAT. The recipient must take account for any output tax on their VAT return and may also treat this as input tax on the same VAT return, subject to normal rules. Where a Northern Ireland seller is sending goods to a VAT registered customer in the EU, the Northern Ireland seller should zero rate the goods. The seller must continue to submit an EC sales list, accurately accounting for the supply of such goods. However, as suppliers of services are not covered by the NI protocol, these do not need to be reported on an EC sales list. Next slide, please. There is a new requirement for businesses carrying out transactions with the EU to use the XI prefix when communicating with EU systems or businesses, for example, on invoices they issue to EU businesses. This requirement applies to VAT registered businesses who receive goods in Northern Ireland from VAT registered EU businesses for business purposes, who sell or move goods from Northern Ireland to an EU member state, or who sell goods that are located in Northern Ireland at the time of sale. HMRC have already identified certain businesses that require the XI prefix, and they contacted those businesses before the end of the transition period. However, businesses can notify HMRC to request the ability to use the prefix through submitting a G form on gov.uk. And businesses that have an XI prefix will continue to appear on VIS on the web. Next slide, please. The EU VAT refund system will be available to VAT registered businesses who have an establishment in Northern Ireland and who make supplies in or from Northern Ireland, excuse me, or EU intra-community acquisitions. Now, businesses that meet those conditions will be able to use the electronic EU VAT refund system for VAT incurred in an EU member state for invoices covering goods only. If a business doesn't meet these conditions, or the VAT invoice covers a transaction in services, the EU 13th directive process must be used. Under this process, a claim must be sent to the authorities in the EU country where the VAT was incurred. And you can find further information about this process on the EU Commission's website. Next slide, please. So I will now talk through situations where goods are sold from Great Britain to the EU and they go via Northern Ireland. The VAT treatment will depend on where the goods are when the transfer of rights to the goods takes place. If the goods are located in Great Britain at the time of supply, the seller should charge the customer VAT and account for it on its VAT return. Only the EU customer can recover the VAT, either using the EU VAT refund system, or if they're VAT registered in the UK, they can use their UK VAT return. If an onward supply procedure is used, import VAT will be due in the EU member state of destination and accounted for there as acquisition VAT. Additionally, if a customs special procedure is used, such as transit, import VAT is due where the goods exit the procedure. The importer must tell the seller when they have used one of these procedures and provide the required references in order so that the seller can zero rate the export. Next slide, please. So here's an example of that journey. We have Samir's London-based VAT registered business selling goods to a customer in Dublin. Now the goods will be transferred to from London to Dublin via Belfast. So to begin with, the goods are being kept at Samir's premises in Great Britain and are sold to the customer in the Republic of Ireland while they are there. Samir should charge UK VAT to the customer. Samir will charge import VAT, which should be accounted for via his UK VAT return in the same way as output VAT. So the goods make the crossing to Northern Ireland and no additional import VAT is payable as part of the customs process. And after this, the good can move freely from Northern Ireland into the Republic of Ireland. The goods arrive at the customer's address in Dublin. The customer can then recover the VAT paid either using the EU VAT refund system, or if VAT registered, they can use the UK VAT return. Next slide, please. So if the goods make the journey from Great Britain to the EU via Northern Ireland, but they are moved to Northern Ireland before being supplied, then two separate movements need to be accounted for. The first is a movement of goods, of own goods from Great Britain to Northern Ireland by the seller. And as explained previously, this will consist of output VAT and input VAT entries on the VAT return. This is then followed by an intra-EU sale. Next slide, please. So here's an example of this journey. So Charlie's London-based business moves goods to Northern Ireland in preparation for selling to customers while they're there. The goods are transported from London to Belfast. Charlie will then make a sale from Belfast to a customer in Dublin. So the goods therefore begin at Charlie's depot in Great Britain. They're then moved from there to be stored in a depot in Belfast. The goods make the crossing from Great Britain to Northern Ireland, and Charlie must account for this as a movement of own goods to Northern Ireland, accounting for import VAT as if it were output VAT, and can reclaim input VAT subject to normal rules. The goods are moved to Charlie's Belfast depot. After this, they are then supplied to a customer in Dublin. This is accounted for as an intra-EU sale. Now, the goods are then freely transported to the Republic of Ireland and arrive at the customer's address in Dublin. The VAT is reclaimed via the customer's VAT return if they're VAT registered. Next slide, please. So this is the reverse journey where a good is sold from the EU to Great Britain and they move via Northern Ireland. In this case, the EU business should charge the customer UK VAT and they'll have to register and account for the VAT on a UK VAT return. The UK customer will be able to reclaim the VAT as input tax subject to the normal rules. So this, an example of this journey, Abdul's Dublin-based business has sold goods to a customer in London. The goods will be transported from Dublin to London via Northern Ireland. So the goods begin at Abdul's premises in the Republic of Ireland. The goods are sold to a GB customer while they are there. Abdul will need to be VAT registered in the UK and should collect UK import VAT at the point of sale and account for it via the UK VAT return. The goods are then freely transported to Northern Ireland and then make the crossing to Great Britain. When they arrive in Great Britain, no additional import VAT is payable as part of the customs process. The goods are then driven to the customs address in Great Britain. The customer is able to recover this as input VAT via their UK VAT return, subject to normal rules. So that concludes this bit of the presentation. I think in the next couple of slides, we have outlines of some of the pieces of guidance that relate to what's been discussed by ourselves so far. So if we move on to the next slide, please. So here we have the guidance pages that cover postponed VAT accounting and imported goods from rest of world. On the next slide, I think we have a couple of supplementary pieces of guidance. And on the next slide, we have the titles of the guidance pieces that relate to how VAT is accounted for under the Northern Ireland Protocol. So that concludes this part of the presentation. I will now hand over to, I think, my colleague Holly to cover the next part, which I think is on Intrastat. Thank you.
Thanks very much. Hopefully you can hear me now. So I'm going to briefly talk about Intrastat. So the slide you can see sets out the circumstances that Intrastat declarations are needed, and I'm going to add a bit more detail to that. So starting with imports from EU to Great Britain, the introduction of stage controls mean businesses can delay submitting customs declarations for non-controlled goods. This means that customs import declarations are not a reliable source of data during 2021 for statistical purposes. This would leave significant gaps in data to compile accurate and timely trade statistics. Consequently, to avoid this, monthly arrivals declarations will continue to be required during 2021. For exports from Great Britain to the EU, dispatches declarations are not required for exports from Great Britain to the EU. Data will be collected from customs declarations. For the movement of goods between Northern Ireland and the EU, the Northern Ireland Protocol legally requires HMRC to collect data for goods movements between Northern Ireland and the EU through the Intrastat system. Any UK VAT registered business exporting goods from Northern Ireland to the EU or importing goods into Northern Ireland from the EU who trade above the thresholds will be required to submit Intrastat declarations. This will remain the case as long as the protocol is in place. For Great Britain to Northern Ireland, businesses are not required to provide Intrastat declarations for these movements, and also for the movements vice versa from Northern Ireland to Great Britain. I've got a few Intrastat colleagues who can answer questions if needed, but we have got a website and also an email address that I can provide to be sent out afterwards for any specific Intrastat questions. Thanks very much.
Okay.
Hello, this is Kevin. We're just going to put up a quick poll, which we would like you to all participate in. There's choices to pick from, and this is anonymous, so you can be completely honest. We're looking for the information so we can feed it back to the HMRC. So the polls are about to be pulled up. I think we've got about four different polls, or 4 or 5 different polls. Thank you very much.
Okay, interesting to see in that poll that the hosts and panelists cannot vote. So I couldn't vote, but I'd still like to say a huge thank you to David, to Will, to Philip, Holly, and the whole of Helen's VAT team. That session did definitely not disappoint. We do have lots of questions coming through. So if you don't mind, let me start putting those questions to Helen and her team and to the rest of the panel. The first question that has come through on the VAT is that, is there a fear of double counting statistics from goods that are on intrastat declarations that have also had an import declaration? I think, Holly, that would be a question for you.
Yep, hang on. Sorry, I'm just checking with my colleague. Is it possible to go to another question and come back to that?
Okay. Should we then pop another one? To use postponing for VAT accounting, is there a requirement that an importer owns the goods or has title at the time of importation?
Yeah, David Pruden here. The rules on use of postponed VAT accounting are essentially follow the guidance that has been published in Revenue and Customs Brief, most recently in Revenue and Customs Brief 15 2020, which outlines the circumstances where import VAT can be recovered as input tax by the owner of the goods. So essentially, and there is a section about PV in that piece of guidance. So essentially, the same rules apply for use of postponed VAT accounting as apply on as are described in that Revenue and Customs Brief, which explains the circumstances when an owner can recover import VAT as input tax. The other options are available. Businesses could also, as an alternative, use IPR.
Okay, yeah, I think there was just sort of a little bit of concern about the a new regulation that I think came in 2019, where it had to be the owner of the goods that was VAT registered would be the only party that was entitled to reclaim the VAT when they sort of crossed that international border. So I think
there was nothing new about that. That had always been HMRC's position. It was simply that this wasn't being correctly applied by some people, and there was the Revenue and Customs Brief, which was published in 2019, outlined and put beyond doubt the correct procedure. And also advised what those that had been getting it wrong should do at that circumstance. There was a further review which led to the publication of the second Revenue and Customs Brief in October last year, and that's also now reflected, I think, in guidance available on gov.uk.
That's clear. Much appreciated. Thanks very much. What I'm going to do is maybe switch between panelists so that we get to everyone participating. Jeremy, a question for you. If duty is overpaid while we were members of the European Union, is that duty refundable? To whom is the application made? And who repays that actual customs duty?
I'm afraid I would have to look that one up. I would start looking in the the law relating to repayments generally in both the law now and the law that was in force at the time, that the rights to the repayment exist. I'd have a look at the own resources regulation of the EU, and then I'd have to have a look at the provisions, the transitional provisions in the treaty as to how we were handling the budget. I wouldn't approach it any other way except by looking out. I know it's not a very good answer, and I can't give you an answer. I've not done the exercise for anyone, so sorry about that.
An interesting question. Yeah.
I'd take the view that liabilities have been preserved. I mean, I'm in principle, but a liability is fixed, and therefore, if there was an overpayment, then that liability, the payment was made above the amount that should have been paid. So it should, in principle, be repayable, and it shouldn't matter when that liability arose. Who would repay it is an important point, and it would be, if it was paid to HMRC, then it should be reclaimed from HMRC, I would have thought, but I'd still want to look it up. I think those principles would apply, but I couldn't give you chapter and verse, and I would want to do so.
Yeah, I think it's very interesting, because a portion of that revenue would have gone to HMRC and a portion would have gone to Brussels. Are they each going to give sort of a bit of it back? Very interesting question, yeah. Mm-hmm.
Yes, I mean, that's right. And the bit that goes to Brussels would have only gone to them if it was actually due. Mm-hmm. So in theory, UK should be able to get it back from Brussels if it had to make the repayments.
Mm-hmm. Would hate to be involved in that discussion, but thank you. Question for Lord Lilly. What can be done to promote the production of goods and services you alluded to in your presentation? Production does appear to have stagnated here in the UK.
That's generally across the board. I'm not a believer in government picking winners. As someone said, government's not very good at picking winners, but losers are very good at picking governments. And once governments start trying to subsidize them, they just waste a lot of public money. We tend to exaggerate the extent to which we don't produce things. We don't produce things we buy in shops. We produce, a third of the world's jet engines, but I never go and buy a jet engine in a supermarket. So a lot of our stuff is high-tech stuff that you don't buy yourself in terms of goods, and the other is services, which again, one doesn't buy at supermarkets. But there's no doubt we have lost some industries we needn't, and some are smaller than they could be. I just think we need the government to promote the industry we have, say, we produce wonderful cars, we produce wonderful fish, get out and buy it. And to our supermarkets, why aren't you providing our fish in the supermarket, a wider range of fish than those which the British have traditionally consumed, to include some of those that we export and which are highly valued overseas. So things like that we can do, which will boost demand things. Above all, I think it's very, very strange that we buy so few of the cars that we produce, even though the rest of the world seems to like them.
Thank you, Lord Louis. I don't drive a car produced here, but I'll bear that in mind in future. A question for David. An intermediary applying for CFSP to get authorization to submit that supplementary declarations results in the applicant trying to complete a form designed for an importer, i.e. there are many questions that do not apply. The applicant is asked to supply a list of commodity codes and clients that may not be known at the time. The applicant is required to submit a final supplementary declaration. Care must be taken to ensure that the client is supplied all EIDR declarations so that this can be done correctly. Where does liability fall if the client has not supplied the intermediary with all the EIDRs? Does the question make sense? And I can see exactly where it's coming from. That an importer would ask a customs broker to submit their supplementary declarations on their behalf. But it is obviously that importer that has brought in everything under EIDR's responsibility to tell the customs broker about everything that is being brought in. What if a shipment has been missed? Where does that liability sit?
I would say that this is fundamentally a customs question rather than a VAT question. So I'm not sure I could say anything particularly useful from a VAT perspective without the main answer in that circumstance would actually be the customs answer to that question, on which the VAT there may be VAT consequences as well. But I don't think I can usefully say anything from that perspective.
I was directing the question to the other David, David Falali.
The problem with there being too many Davids in the world at times, aren't there? It's one that I'll take away and check with my my colleagues that are looking at liability. One that I'm afraid I don't know the answer off the top of my head there, though. As you say, Des, I can see where that question is coming from around that EIDR process and the supplementary declaration. And it's a good question, and one I'm a bit annoyed I don't know the answer off the top of my head, but I'll do some digging. And I know, Des, as you said earlier, that you'll be compiling all the questions that have come in, and we can look to get all of those answered and back to you. But one I'm afraid I don't have an answer to right now.
Okay, thank you. Now for David at VAT. HMRC PVA statements are always available a month later. How can we continue to comply with making tax digital for VAT with this scenario, as we will not have a digital record of our in our accounting system for the period for the VAT return?
Okay, yes, sorry, a VAT question this time. Sorry about the last one. Yeah, so well, the first thing, the PVA statements will generally be available by the 6th working day of the month following. So obviously that, depending on whether you've got weekends in place, it shouldn't be a month later. So for say February, you know, the statement, I can't remember exactly when they were produced, but it should be something like the 8th or 9th of each month. With regard to the question itself, sorry, I had given myself an answer. I did have an answer to that, which I seem to have mislaid. Can I come back to that one? The rest of the answer to that.
Okay, Lord Lilly, if we could, question here, is there any merit to looking to better trade relations and cooperations with other members of the Commonwealth? And is anything being done to promote this?
Well, I know that's there's a lot of support for that idea, but the Commonwealth isn't a particularly an economic organization. It doesn't have an economic framework. As I mentioned, 5 members of the Commonwealth are members of the CPTPP, so we'll be joining with them if and when we join the CPTPP. Hopefully we'll have separate and deeper agreements with some of them as well as that. I think it's really up to us to try and forge bilateral agreements with some of them. There are some suggestions for more plurilateral things, for example, to have a business visa, so that if you were a member of the Commonwealth, you could go on a business trip from whether you might be a New Zealander and you want to go to India, or an Indian and want to come from a business trip to UK, or Canadian and want to go to Australia, and it would apply across those things. And such a visa, I think, actually is in existence within the CPTPP, and it could be something we could introduce within the Commonwealth, which would help trade and investment. But I think it's very unlikely we'll have a Commonwealth trade agreement covering all or the majority of members as such. It's more likely to be a network of bilateral deals.
Thank you.
Just one thing to add. Nonetheless, despite the lack of any formal trade deals, the volume of trade between Commonwealth countries is greater than would be predicted by any economic model. So the historic connections between the countries of the Commonwealth obviously does generate trade. There's another piece of evidence that actually trade deals are less important than some other factors, despite the presumption in most debate in this country whether they're whichever side of the Remain leaves argument. I think both sides exaggerated the importance of trade deals against other factors.
Thank you. Next question for Jeremy. The question is, what happens if I walk away from my Northern Ireland obligations subject to the movement of goods between the UK and NI? TSS has acted as a direct representative. Can HMRC chase me before they've exhausted their action against my jointly and severally liable business partner, TSS, who may or may not elect to institute civil action against me later? Yeah, an interesting one. I mean, with TSS acting as a direct representative, they are jointly and severally liable. Where does that work from an HMRC point of view, Jeremy?
That is an interesting one. I'm not sure where the main part of the question is can I pass my liability on to TSS if they're liable and I'm liable? I haven't seen what the terms of service, what TSS is, but if I wouldn't normally. I mean, we've got problems with Crown immunity, for example, and other principles like that. So whether you could actually pass liability onto TSS, I don't know. That might not really be the nature of the problem, because you might have a liability anyway. So it'll be jointly and severally liable for you. You will have to pay the duty if you were the represented person. I'm not sure about direct representation. I'm not sure about what you're doing, what you hope to achieve there. I think I'd need more detail as to the nature of the operation. My mind is full of all of the different problems that arise even with understanding what a situation is when you are not thinking of suing TSS, when you're trying to understand exactly what the decision on the joint decision on the Northern Ireland Protocol means. I think it's clear, although not defined, that you have to, when considering using the TSS, you have to then consider what the fundamental liabilities are and how they arise. So, for example, what is considered to be at risk, and then how can you be authorized to make a certain declaration, and then in what form can you make it? All these are relevant, particularly to people who are thinking of not using TSS, and they're thinking of maybe making their own arrangements for the customs declarations. And I think these are issues which I think are more real. They're going to be harder to deal with. I think the TSS is all very well, but you've got, if on very, very many consignments, you will have so much keying in on the systems. How are you going to get that for a very large mover of goods? Could it be possible instead to have an interface? And what about somebody who says, well, I don't need any of that. Can't I just make my declaration straight into CDS? If they're not, at the moment, because of the nature of the joint decision, if they aren't established themselves, they don't have a company in Northern Ireland, the only solution would seem to be that they would have to have an agent who has a company which is formed in Northern Ireland. So you go on Companies House and try and find a company that is an agent that is formed in Northern Ireland. Those are the issues that are more real and more pressing at the moment and difficult to resolve.
Just thinking about that question, was this not more about something goes to Northern Ireland, there was duty sort of payable because the goods sort of dropped into the Republic of Ireland. Someone didn't pay that duty, so HMRC would have to chase down the collection of that duty. I'm the person that didn't pay that duty, but I use TSS. Would HMRC not have to go at TSS and myself as jointly and severally and if they were not getting it from me, have to get that money from TSS if they acted as a direct representative. And if TSS wanted to cover it from me, would they not have to chase me down civilly? I think that's more around what the question was. People thinking they can sidestep their liability through this direct representation. Is that not a risk? I mean, I've never thought about it before, but it does feel as if there is potentially a significant risk there to TSS.
Well, you mean if TSS were to act in an import and therefore potentially be liable as a representative?
Correct, yeah. Mm-hmm.
Yeah. But in those circumstances, the importer would always be liable. So you're saying, is TSS somehow underwriting liabilities from its clients?
Correct, yeah.
But the relationship that TSS say would have with the customs authority that was going to collect the duty, what right would they have to go against TSS? They'd have the charging provisions.
And sorry, I'm wording this totally wrong, and someone, Mr. Worth, thank you, has corrected me. I mean indirect representative, not direct representative, where they're acting as an indirect representative. Mm-hmm.
Yes. Well, if you would move to on the charging provisions from the liability to then saying that the importer and the represented person are both liable normally. Now, if the so the represented person as the importer is liable. In addition, when the customs agent is an indirect customs agent, the customs agent is also liable. That's in indirect representation under the old terms, or indirect customs agency under the new terms. Now, if that person is part of the Crown, then is that person immune or not? And it's not going to help. I mean, it is an interesting academic question, but it doesn't have any real meaning. I mean, you say they are liable, then okay, that means that the government has facilitated the non-payment of duty. But that's at the moment it's facilitating the movement of the cost of compliance with this free service of TSS. There's not a lot of a difference, and sometimes cost of compliance is higher than the amount of duty involved in the importation. So it's not really a fruitful question. It's interesting academic, but it doesn't really make any difference.
I enjoyed the question and it got me going.
Yeah.
Thank you, Joe. Another one to our VAT colleagues. I mean, the question is, why has the UK not considered fiscal representation for VAT like most EU nations? Would this not provide HMRC with less risk and more control? I think that's one for David, Will, Philip, and Holly. Maybe not. Lord Lilly, we have a couple more for you. One was obviously referring to your presentation. Why do you believe that the NY protocol issues were unforeseen?
Well, when I say unforeseen, I'm sure there were people around who foresaw everything that's happened. But in Parliament, they were unforeseen, barely mentioned. And to the extent that problems were foreseen, it was assumed that they would relate to customs procedures, tariffs in particular, and hence the establishment of the TSS. Nobody, to my mind, mentioned soil on tractors or on seeds, and a whole range of other, or transport of pets or other things. So I was really referring to where the political world was taken by surprise. And it was surprised on the upside by the fact there weren't queues at Dover and that lorries, much higher proportion, had proper documentation than anticipated. But the downside was particularly Northern Ireland. I don't think many people in Westminster foresaw that. a small group of us who meet and discuss these things and take legal advice have been told of some problems which are yet to arrive. There's the problem of labeling. If when we're out of the grace period, goods will have to conform to single market labeling rules within Northern Ireland. That will mean that a supermarket distributing goods will have to get its suppliers to supply a proportion of the goods with European labeling if it's to go on to Northern Ireland. And those suppliers may not want to go to that trouble, and therefore the supermarket will not be able to supply its outlets in Northern Ireland. So all sorts of things like that haven't been foreseen in detail by anyone outside a small minority in Westminster, and that's a sad thing. One reason I attend the ACITA conferences is that as a result, I'm a bit less ignorant than most members of parliament, but I'm still was unable to foresee an awful lot of things.
Thank you, Lord Lilly. David, an interesting sort of short question for you here. I mean, people are asking for an update on a CDS. Focus appears to have moved on this, and do we have sort of any idea on the sort of timetable for phasing out chief and implementing CDS? I suppose the concern is that we've taken our eye off the ball here and do not want to be caught up. Do you have any sort of update for us there, David?
Not specifically on CDS at the moment. As you can imagine, focus has been somewhat elsewhere and ensuring that chief, where that has needed to be upscaled to facilitate the increase in the number of declarations that is coming. I can assure you that work hasn't stopped on CDS. And Des, as you know, we work with you a lot. I know you're a member of the JCCC, to which I know CDS is often a topic of questioning and interest. So all I can really do is provide you kind of assurances that as soon as there are more developments and more announcements to be made around CDS, we'll make sure that ACITA, Des, and your members are all up to speed with that as it comes. It is still bubbling under the surface, but no specific updates at the moment.
Thank you. And Jeremy, another sort of interesting one for you. If an unintentional underpayment of duty is discovered, i.e. Anti-dumping duty, who enforces the collection thereof now if this happened pre-Brexit, and who receives the duty, and more importantly, who receives any applicable penalty if the collection is successful?
Right. Anti-dumping duty has been enforced by often applying criminal penalties. So that would be on the basis of an offence committed at the time of the importation, and that would be the responsibility for the prosecuting authority of that jurisdiction. The failure to pay an anti-dumping duty could also be subject by the means by which the duty wasn't paid. If it was just an amount treated as an amount of customs duty, then it could be itself subject to interdiction by a civil penalty. That I don't know whether that shouldn't be a problem either way. And with our new anti-dumping duties and various safeguard measures we'll have, those should follow ordinary provisions. What might be a problem would be those cases which straddle the end of the transition period. And I think you'd look at the facts, because it will all come down to some facts, and then you would check on exactly when the liabilities arose, who the liable person was. It's unlikely that anyone is going to be relieved. It's by the fact of their being. I mean, it would be bad. It would be a bad transition legislation if someone were to would be no longer to be liable because of their being of the UK leaving the EU. So I would expect liabilities to just be preserved and to be enforced in a proper way. It's similar to the question on repayments. But if you wanted an answer in a specific case, you really would have to investigate the specific case, because there's so many different ways of having liability and so many different liable persons. But once you've done that exercise, you would find that there would be a liable person. And I do not believe that the law would allow anyone who was liable at any particular time to escape just because of the transition. I think that's most unlikely to be the case. But to prove that, you would have to go through some of those hokey-cokey pieces of legislation and all of the consequential ones, which I have not yet grappled myself with. I've had a look at some liabilities through the transition provisions, and they're even harder to understand. There was also a serious error made. They were, for which they had to, at the end, very, very late in the process, they had to amend so many of the earlier transition provisions because they referred to exit day and they didn't refer to IP completion day, and they had to change those references. So that's where you would have to do the work. But I very much doubt if they've got it so wrong that anyone would escape liability. And it probably, I very much doubt, although there's a lot of money that we will be paying, the Danegeld that it's so called, I doubt if anyone is going to be out of pocket as a result of any of the customs authorities are going to be out of pocket. They will be able to recover somehow from the liable person.
Okay, thank you. Next question is for our HMRC VAT colleagues. This is quite specific on the low value consignments. One of the members has had reports from many of their clients who are struggling to register. Is there any HMRC contact point they can go to for help? That is the sort of David Wool, Philip and Holly group.
Hi, yes, I think there is a general phone number for queries that we're directing customers to, and that is I can send over the phone number, or I can type it out in the Q&A box if that's best.
Please, if you could just put it in the chat box there, then Kevin can circulate it with with all the members. Thank you. That'd be much appreciated. Lord Lilly, I think we are getting close to the end, but another question for you. Do you think the SPS conundrum is a solvable issue? And do you think either side invoking Article 16 is a realistic possibility?
I'm not sure whether it's soluble, but the problem with SPS is that it's not primarily about outcomes, it's about processes. So the rules haven't changed either side of the Irish Sea as far as food and animal products is concerned. And essentially the same levels of safety apply now as did before we left the EU, but goods have to go through a new process when they move from GB to Northern Ireland, very often, which duplicates processes they've already done and is unnecessary. And those processes, as I mentioned, tend to be designed as much to exclude goods from the European market as to ensure that the goods are safe and healthy. The nearest to a solution does seem to be what I mentioned, which isn't my idea, but it's being proposed by others, that we simply treat the EU single market rules like we treat EU tariffs and say they will only apply to goods which are at risk of crossing the border, and goods which clearly designed to and going through supply chains that are going to mean that they're consumed in Northern Ireland will not have to go through this further SPS checks and processes and compliance, unless, of course, the rules in the UK change on a specific product and are different from those in Northern Ireland, then on that product, they would have to go through the EU rules. That seems to me to be the most likely to resolve the problem within the framework of the Northern Ireland Protocol, but it would require the agreement of the EU, which they ought to give in all good faith, because they've said that they're committed by good faith to achieve a practical outcome that doesn't impede trade. Would Article 16 be invoked? Well, we've seen it invoked once, albeit relatively briefly, by the EU, totally out of context on the issue of vaccines, to stop vaccines going over the border from the Irish Republic and into the GB. Not that there was the remotest risk of that really happening, but so yes, they could be invoked by Britain. We would clearly, the government would be reluctant to do so, but it has the whole purpose of Article 16 is if there is serious diversion of trade or risk of social disruption, you can take whatever measures are necessary. They're supposed to be proportionate, they're supposed to be limited in time if at all possible. There can be appeals against them to arbitration and so on, but it's far from unlikely that Article 16 will be invoked.
Comforting, thank you. I have another question for David. When is GVMS required to be used? And is the requirement different for Northern Ireland and European Union routes? Does the requirement vary depending if the goods are traveling under community transit, an ATA carnet or TIR, EIDR or a customs declaration?
I can cover some of that. Not particularly fully up to speed with GVMS with regards to Northern Ireland, but more generally, GVMS is up and running for transit. So currently, any goods travelling between GB and the EU that is travelling under transit, GVMS can be used, and putting the MRN from the TAD into the GMR, the goods movement reference that is created within GVMS, that is fully up and running as of now for those transit movements, as we weren't able to, transit wasn't able to be moved to in stages like other customs controls due to its nature being kind of a more wider international agreement across both the EU and other member parties to that. GVMS in its full sense will be, the delivery of that has been put back to January 2022, because that is at the point at which we're no longer using the staging in of customs controls. So the full process for customs declarations and safety and security, whereas you currently do or currently can do with MRNs from transit, input those at that point in January. That is the system where you'd input for a trailer all of the customs declarations, all of the safety and security declarations, and any TADs that are also included in that. So all of those could be arrived in that system in one hit. So there is that is one of the impacts of this 6-month extension, is that the full functionality of GVMS will not be needed until January.
Thank you, David. Question for our VAT colleagues. I mean, many UK businesses in the pharma industry import goods they do not own. They import them to work on them for overseas and now EU sponsors. This is big industry, and these importers are often not sophisticated enough to use advanced customs procedures. I understand HMRC no longer allows UK businesses to reclaim import VAT on goods that are not theirs. Ireland and many other EU countries allow for this. Is it correct that UK businesses will be greatly inhibited in this fashion? I think this is something we did touch on earlier, but it seems to be sort of problematic. Is there any thought, David, on how this could be handled in the future?
I think it is essentially the same question as before, and I'd seen it and had it in mind when answering the previous question. The discussions on this have there have been discussions on this and representations on this subject made with HMRC. And as I said, the second of those two revenue and customs briefs was made on the basis of a review carried out following such representations being made, which was fully considered by both HMRC and HMT colleagues. But again, if there are issues, I guess further representations can be made, but I don't think it's anything that we can add to here. It's a subject which has been subject to long and ongoing discussions. Can I, while I'm here, just answer the question I didn't answer last time, which was about mandated, or about making tax digital and using PVA. So just on that, so if you are mandated to use making tax digital, the first point, probably a clear one, is that you can't manually enter information required for the VAT return into software that will submit the return, because you obviously you have the software designed to work in a particular way. So so users of that, if the software doesn't cover PVA, which in a lot of cases it won't because PVA is new, users simply need to make any adjustments to the main record keeping solution, and then import that into the part of the software that deals with or does the return submission. If the adjustments that need to be made do require some manual intervention to achieve this, that's fine with HMRC. So effectively, you need to make the adjustments outside the main MTD system.
Thank you. Makes a lot of sense. Thank you, David. I think any other questions, as I say, we will capture those questions. We'll share them with our speakers, and they will be published on the website. So at this stage, it's a big thank you to all our speakers, to our members for attending, and to Dinesh and Kevin for the organisation. I found this really interesting and informative, so thanks again to all. The slides will be shared on the website. Any unanswered questions will be answered, and these will also be published on the website. Don't forget, I mean, this is a two-part national. We look forward to seeing you all in part 2 of our national on the 23rd. So a big thank you to all again, and a goodbye from me. Thank you very much. Bye-bye.
Hi, Dinesh, you on?
Yeah, I'm good. Thank you, Jeremy. Thank you for coming on.
Good. Okay, it's
good to see you.
Oh, thanks for organising that, Kevin. Sorry, I had a problem with the. I don't know what it was, because but we resolved it, which is good in time.
Thank you, Jeremy. It was superb. It was excellent.
Oh, good. Thank you. Yeah, I'm sorry I couldn't answer those questions with any particularity, because I mean, we're all involved in far too much work now to answer what should really be simple questions. But anyone who does give you a simple answer to those sort of questions is deceiving you. The legislation, even when you know it and you can find it, is very complex, and I don't think it's well drafted. I'm advising people generally, if they want to know the exact answer, then they'll have to put in some money to get that. And that means involving a wide team of people with different areas of expertise. That they can do that, or they can make sure that their policy or their behavior is straight up and down with customs guidance, with a view to holding customs to that guidance by way of judicial review later on if they need to. That's what I'm telling people. Academically, I mean, some of these questions are really interesting, and to ground them out. I mean, I have done a few for a few clients who really want to spend the money and are interested in that. And so I sort of have a few islands of expertise. Whereas once upon a time, I used to know so many more things. I know less now.
Yeah.
I know how things should be, but I don't know the answers anymore.
Yeah. Jeremy, just a quick question to you. I know you mentioned the UK's UCC and the EU UCC. Where can I find the copy of the UK UCC? Is there something?
Good point. They haven't. A number of editors, Westlaw, LexisNexis, have tried to give you lists of what would be in the UK UCC, but it is by subtraction. So
right.
The GB UCC is quite small. It only involves a few articles, but which articles are they?
Exactly.
I would say that they're all of those articles that relate to prohibitions and restrictions.
Right.
Definitely. If it relates to prohibitions and restrictions or penalties, then it's in the GB realm. The way you can find some of the items is by deducting that by means of deduction, because say if you find that there's an SI which amends textually amends the UCC, and some SIs do, like safety and security SIs, they actually specify UCC articles and they amend them.
Right.
They're obviously only amending the GB. So if in any article, if you find any UK legislation that amends an article of the UCC, it can only be amending the GB version.
Right. Okay.
Because it's not allowed to amend the
UK,
the Northern Ireland or they're not allowed to amend the EU version. Only the Council and Parliament can amend, or the Commission, if it's an implementing reg, can amend the EU UCC. So I've used that occasionally from time to time, but it's really is you've got to understand this expression so far as imposing or otherwise applying in relation to any EU customs duty.
Yeah.
That provision in Schedule 7, paragraph 1 on my first slide, the last paragraph. You've got to understand what that means. And I'm pretty sure that it doesn't mean prohibitions and restrictions. So anything which is in the way of the safety and security or that is definitely not. But you could say, well, what about neutral kinds of concepts?